In the American constitutional system, power is deliberately fragmented. The framers of the Constitution designed a government of checks and balances, hoping that ambition would counteract ambition and that no one branch would dominate. Among these carefully calibrated checks is the federal judiciary, unelected, independent, and expected to interpret laws with fidelity to the Constitution.
Senator Cruz.
It's long been said that hypocrisy is the tribute that vice pays to virtue. I have to admit I'm enjoying listening to my Democrat colleagues suddenly discover the virtues of the rule of law. After 4 years where they brazenly supported the most lawless Department of Justice and the most politically weaponized Department of Justice our nation has ever seen. We just heard the senator from Rhode Island talk about the imperative of protecting judges. And yet not a single Democrat senator cared about the violent protesters that showed up outside Supreme Court justices' homes, including, I might note, female justices like Justice Amy Coney Barrett, threatening their family, and Joe Biden's attorney general didn't do a damn thing and refused to enforce the law to protect those judges. Why? Because he agreed with the violent protesters and he wanted to intimidate and threaten those judges. Professor Bray, under our Constitution, who should decide elections, the voters or unelected judges?
The voters are the ones who should vote in the election according to the laws, and the laws sometimes have to be applied by the judges if there are cases.
And under our Constitution, who is charged with making policy decisions? Elected representatives elected by the people or unelected federal judges?
I think the question of policy, Senator, is a little broader than the particular case. So the laws should be enacted by Congress. That's where the fountain of law.
Policy decisions are the elected branch.
Right.
Law is the province of the court. Policy is the province of the elected branches. These are not complicated. Professor Bray, let me ask you this. Do the federal courts have power to issue remedies for people who are not parties to a case?
That's a question I agree is not complicated. They do not have that power.
Is the phrase nationwide injunction or universal injunction found anywhere in the Constitution?
It is not.
First chart. In the first 150 years of our republic, how many nationwide injunctions were issued?
My view is that there were not any until 1963.
0. Now fast forward. How many nationwide injunctions were issued in the entire 20th century?
It's a small number. I would think it would be a dozen, give or take. It's not large.
27, actually. Excluding Trump's first term, how many nationwide injunctions were issued in the last 20 years?
Far more than that.
32. From 2001 to 2024 against Biden, Obama, and Bush, 32. And how many nationwide injunctions have been issued in the last 2 months alone?
There have been quite a few.
37. Let that sink in. There have been more nationwide injunctions in the past 2 months against President Trump than in the entire 20th century. There have been more nationwide injunctions against President Trump in the last 2 months than both terms of George W. Bush, both terms of Barack Obama, and Joe Biden's term. We saw during the Biden presidency lawfare, indicting President Trump 4 times, using the machinery of justice to attack him, and that was an attack on democracy, because Democrats today hate democracy. Democrats today are angry at the voters for re-electing Donald Trump and electing a Republican Senate and a Republican House, and they engaged in lawfare to stop democracy from operating. Understand, this is the second phase of lawfare, second chart. This is the second phase of lawfare. Now that their efforts to indict President Trump and stop the voters from re-electing him have failed, they're going and seeking out individual radical judges to try to shut down policies, and they are forum shopping like crazy. Give me any loon judge put on the bench by Obama or Biden who disagrees with a policy. We just saw a judge flagrantly ignore U.S. immigration law.
But in recent years, The boundaries of judicial power have come under increasing scrutiny, with one legal mechanism standing at the center of this storm: the nationwide injunction. A nationwide injunction, also called a universal or nationwide vacatur, is a court order that halts the enforcement of a federal policy or executive action across the entire country, even for individuals who are not directly involved in the underlying lawsuit. While seemingly technical, the implications of these rulings are profound. With the stroke of a pen, a single district court judge can suspend a federal regulation, immigration rule, or environmental policy, regardless of where the lawsuit was filed, and regardless of which branch of government enacted the rule. This remedy has become a legal flashpoint, and increasingly, a political battleground. For the first century and a half of American jurisprudence, such sweeping injunctions were virtually non-existent. Courts generally adhered to a more restrained approach. Their rulings were meant to resolve the disputes of specific parties, not to impose broad national policy. The use of nationwide injunctions did not meaningfully emerge until the mid-20th century, and even then, they were rare. That has changed dramatically in the 21st century. Particularly during the Obama and Trump administrations, their use has skyrocketed, turning what was once an extraordinary judicial act into a relatively common tool for challenging federal authority. The legal community remains deeply divided over this trend. Supporters argue that nationwide injunctions are often the only effective way to prevent harm caused by unconstitutional or unlawful policies, especially when those policies are designed to affect every American. Critics, however, see them as a violation of Article IIE's limit on judicial power.
We love the democracy, and I believe what we should be having is a civil debate about how we can best, if Donald Trump wants to make changes to the government, we should be doing it in a legal way, not how he's doing it. And the only reason there's all these injunctions, Senator Cruz, is because he's violating the Constitution. Why would Trump-appointed judges...
Why don't you file them in red districts?
Senator Cruz.
Why... What did you just say?
Why don't you file them in red districts? Why are the Democrat attorneys general seeking out left-wing,
my
blue,
esteemed colleague,
Quite patient with Senator Cruz's activity in this bill.
Senator Whitehouse.
He's entitled to...
I'm just going to ask for a point of order. Madam Klobuchar, Senator Klobuchar.
Senator Moody, we have debates on this committee. They occur regularly.
Let's let her have her time, and then we'll get back to that. If you want to wait, we'll get back to Senator Cruz.
She's welcome to
Senator
answer the
Klobuchar,
question or
go
not.
ahead.
It's her choice.
Go ahead.
I'm so
and I would encourage you to answer.
Following Senator Cruz once again.
Excuse me?
But I will say
Excuse
this.
me? I didn't hear you. What did you say?
To be following him. He and I have a long
I was permitting you your time to continue. To be following him in order. Excuse me. Go ahead, Senator Klobuchar.
During hearing.
Go ahead, Senator
That's what I'm referring to.
Go ahead.
And I will take more than my time, since he's taken more than his time to yell at me.
Go ahead.
So what I
I'll
will
mark the
say
time.
is that...
I'm not yelling. I asked a question.
Senator Cruz, please, I'll give you time. Senator Klobuchar, I've got the time, and you'll be allotted
I
time.
am making the strong case that the reason all these cases have been filed, and the reason that these judges who have been appointed by Ronald Reagan, yes, they still exist, and the Bushes and Donald Trump, judges appointed by Donald Trump, have been making these decisions is because this is not legal. Donald Trump himself has used his social media account, the White House account, to post an image of himself wearing a crown saying, "Long live the king." The issue is that we do not live in a kingdom, and Elon Musk is not his court jester. Ours is a nation of laws in which no one is above the law. That is why 39 different judges from vastly different backgrounds, appointed by 5 different presidents, have made clear that these are illegal actions. And these judges have rightly blocked these actions. And it is important that we not lose sight of the underlying cause of these injunctions. It is not that these judges are crooked or lunatics or evil. Those are words used by the president and his allies. It is because the administration is violating the Constitution.
They argue that such injunctions grant unelected judges outsized influence, effectively allowing them to overrule national elections and act as de facto policymakers. When a single judge can shut down a policy supported by Congress or the president, critics argue, we cross a dangerous line where the judiciary becomes a political actor rather than a neutral arbiter. The integrity and safety of the judicial system, once a cornerstone of American stability, is increasingly under threat from within the political class itself. And yet, this is not just a political story. The use and misuse of nationwide injunctions raises deep philosophical questions. What is the proper role of the judiciary in a democracy? Can courts remain neutral when the political stakes are so high? How do we balance the need for uniform relief with the risk of judicial overreach? Furthermore, the public consequences of these injunctions are immense. When a judge blocks the enforcement of a federal rule on reproductive rights, immigration, healthcare, or environmental protections, real lives are affected, millions of them. As Professor Vladek noted during the hearing, these decisions are not simply legal abstractions. They determine whether cancer research continues, whether asylum seekers are deported, whether families have access to healthcare, and whether executive authority is held in check. In this light, the debate over nationwide injunctions is not merely a quarrel among lawyers or a point of academic interest. It strikes at the core of American governance. It forces us to confront fundamental tensions between majority rule and minority rights, between speedy action and careful deliberation, and between law as a shield for the powerless or a sword for the politically motivated. At stake is the question whether our system can still function when the basic premises of law, legitimacy, and institutional restraint are being tested daily. As the political climate grows more contentious, and as executive actions grow more sweeping, the judiciary finds itself in an increasingly precarious position. Judges are being called upon to resolve disputes that reflect not just legal ambiguities, but a deep crisis of national identity about who we are, what we value, and how power should be wielded in a democratic society. The national conversation about nationwide injunctions, therefore, must not be reduced to partisan talking points. It demands a serious, measured examination of history, constitutional design, and the practical needs of justice in a divided nation. Only then can we begin to answer the urgent question that now faces the courts, the Congress, and the country at large. What kind of democracy do we want to be?
What happens when they use these kinds of words? You see more and more threats against judges. And that is what we're seeing. That is why federal judges and the U.S. Marshals, who are responsible for protecting them, are sounding the alarm about a spike in threats against judges. This is serious. And unlike what Senator Cruz said, I'm remembering when the threat was made, the horrific threats, and the man was in Justice Kavanaugh's, on his neighborhood, on his street. On a bipartisan basis, we came together and got more funding for the judges and changed things so that they had more protection. So what he said was completely untrue in terms of Democrats and Republicans decrying violence. We didn't just decry the violence, we actually did something about it in response to a court that is run by Justice Roberts, who is a Republican appointee. So I think that kind of language actually makes the situation worse when it's not even true. But unfortunately, Senator Cruz left, so he did not hear my response to what was a lie. President Trump's attacks on these judges has made for some major risks for these judges. I would ask you, Mr. Panuccio, and not in a partisan way, just normal, as a partner in a law firm, have you ever taken to social media to personally attack a judge who ruled against you?